Hello, everybody. What is going on today? We are live. Am I live? I'm live. Everybody can be heard, right? Yeah. Hello. Welcome to the non-sec craziness, right? So we have the latest court filing in the non-sec show. Just a little house cleaning. I was supposed to put out my video detailing my change perspective of the Michael Flynn case. That is going to come tomorrow. I lost so much time today with Uncivil Law. It just became crazy. Like we spent 4 hours looking at the the Mike Flynn Umbunk Court of Appeals thing to this morning. It was great though. It was fun. We had like 500 viewers. It was great. And just for all of you to know, and I know you, if anybody's watching my channel, it was funny because like a couple of days ago I was celebrating 6,000. So like overnight I've got like another 1,000 or 1,200 people who signed up who are now. So the channel's growing, everything's going great. So I just want to thank everybody for their support. I try to keep this legal stuff interesting. You know what I mean? And sometimes it's just it is a pain. It's a pain. So I know I have it's funny because I have a case that might be going to trial. So if it goes to trial, I might have to disappear for a little while and litigate that case. But I'm hoping it settles. But we'll see. Nick Suter's in the house. Exiled. What's going on? Nick, it's funny. I just sent Nick a link. Nick, I thought you wanted to get in here. Nick is like my legal buddy. So whenever we do the legal stuff, I like to get Nick inside here. So Nick, I don't know, but Nick might be. He's got the girls. How's everyone doing? Before I get into it, I just want to say hello to everybody. The whole Navy. Boom. Exiled. Nick, you got to check Discord, man. You got to check Discord. Here, I'll send you a link on Discord so you can jump on in. But now you're going to make me change up my whole setup and everything. So, but it's all good, though. It's all good. It's good to have some fresh perspectives instead of me just monologuing to the crowd. So let me send Nick the link before I get started, because I'm a monologuer. I can monologue. I'll monologue with the best of them. I'll be here for 4 hours hitting them with the monologues. All right, so that's Nick's got the link now. It's in Discord. Nick, you check that out. So while we wait for Nick to get in here, how's everybody else doing out there? Again, super chats are welcome, and thank you to all my members, and thank you for those who've signed up on Patreon, those who've signed up to channel memberships. This is it's amazing. So I'm it's funny because soon I'm gonna have to change my moniker, like my whole thing in my description is help me get to 10,000 subs. I'm getting closer. So next thing is gonna be 100,000. It's funny because I thought 1,000 was gonna be like a dream. So now where I'm at I'm at 7,000. So it's amazing stuff. So thank you to everybody, and thanks for everybody for even watching this. So let's look at the filing. It'll be good for me to give you guys like a little background where we're at. Nate, I stayed up late for this. It better be good. It is good. It is good. Now, I want to start with saying one thing. I got Nick from In Time in here, so I'm going to add him to the stream. Nick from In Time, what's going on, Nick, baby? We cannot hear you. I hear nothing. I hear absolutely nothing, Nick. Is it me or is it you? I think it's you, Nick. Do you guys hear Nick? Because I know you guys hear me. Do you guys hear Nick? Nick, you might have to go to where it says camera and mic and hit your mic up. I see Nick talking. I see you talking, Nick. I can read lips. Nick says, I got $100,000 check for you. Yes. For me only. That's right. Just say something or wave your hands or something if we have an agreement. 50-50 partners, right, Nick? 50-50 partners. Nick is going to be back after he fixes up his audio issues. Let me see Secret Squirrel. I'm sorry, Secret Squirrel. I see you through a super chat. Secret Squirrel. I love Secret Squirrel. I stayed up late for this. This better be Secret Squirrel. I'm about to hit you with the bomb. It's funny because I got like 4 messages from people saying, hey, Red Rhetoric is trying to kill your stream. They're going live. Listen, I don't care if I got 5 people here. So what? It's, I like to give you the law, and if people want to hear what I have to say, that's fine. If they want to go over there and hear Reds, that's fine. I might watch it myself later too. So, all right, we're gonna try this thing again with Nick.
I don't any luck.
Right, there it is. We can hear you now.
Oh, there it is. It was. Oh, I was on the wrong setup. All right, the list of complaints I have before the show even started, but that's actually all right, Nate. I was calling. I need a good lawyer. I was calling. So if your lamp is free, great. If not, I'll talk to you instead.
It's all right. It's all good. It is all good, baby. $20 Australian, doing great work, Nate. Oh, thank you, Stuart. Thank you. I appreciate it, Stuart. I really do. Thank you. And Stuart is one of the soldiers up in the uni rock. And I'm a uni rocker too, so I'm up in the uni rock Discord with Stuart. So we're uni rockers, baby. Shout out to uni rock. Go ahead.
Been on it. He used to be on In Time. He used to be on In Time a lot, man. But it's like, okay, I guess he's moving up in the world or something. Fine.
Nah. Unirock's my brother and my boy, Minister Sobriety. I love it, Minister. I love his. Look at this. Do you sleep? No, you kept me up for 4 hours. You kept me up for 4 hours on civil law. Steve's wrong. Rock or BS. Sinister Purpose. What's going on? Hey, I gotta say. If you want to hear some great streams, you gotta watch Sinister Purpose. Sinister Purpose is hilarious. It's great viewing material. Got to check out the channel. Sinister Purpose. Somebody throw Sinister Purpose's channel up in the chat. It's really, really good. And £5 worth $10 US. That exchange rate is working for me. Thank you, Exiled channel member, and Exiled was the one that helped me with my Steve video, the video about the whole Dale David Warden. So Exiled is a great resource, and she does her stuff. So thank you so much, Exiled. You don't know how great Exiled is. Exiled is really good. Dana McWhite. All right, Red Line Christian debates are hilarious. No wonder he films rockets, and the official videos of rockets looks way better than that fake 4K junk he says he has. Dana McWhite hitting them hard for $10. Thank you, Dana. So, Nick, what's going on? What's going on? Now, if you guys don't know, hold on. Let me give you a proper introduction. If you guys don't know, my man Nick is over here. If you don't know Nick is on In Time. Great show. I've done this show, I think, last week. We had a phenomenal time. Nick, plug the show. Let these people know what's up.
In Time. Let's see. We've got Tony Designs is head mod over there. We've got we do breaking news coverage and updates. We also do interviews, culture, science, stuff like that. So we've got a great show that I'm really looking forward to. First time ever, Dr. Richard Carrier and Ozzy together on history of religion. Not history. What am I saying? Philosophy of religion. I think that's going to be great. We just did Deconverted with it wasn't his deconversion story. It was Importance of Debate with Matt Dillahunty. And so it's I have a blast doing it, and we have a whole bunch of guest hosts. And for the news updates, we do like breaking news, and we also just cover whatever's been going on. It's been a little depressing recently, I gotta tell you, but we have ProLib Ethan helps us out with that, so it's I have a lot of fun. I hope you guys will check it out. But thank you we got to have you back on a few more times. We're already like scheduling stuff. And there's Tony dropping the link. So
Tony hits the link. Hit that link. Subscribe to my man Nick and In Time. It's a phenomenal channel. And again, it's our community here is all growing. We're all growing together, and it's great to be able to have these type of conversations. So please check out In Time, check out Richard Carrier and my man Ozzy, who I always have these battles with, but Ozzy is a phenomenal resource, and it's going to be great. I'll definitely be checking it out, and I hope that you guys will check it out too. So now let's just get out here, because I know it's funny because I have all these fans on the other side of the world, and it's late, I know, for them. So we got to get into the details. Let's get into the details of Steve's new filing. So for all of you who don't know what's going on, which, since I got like 1,000, I got like 12 I got about 1,300 new people yesterday. So I got to just give them a little background. Here's the background. There was a show here on YouTube called The Non Sequitur Show. The host got into a big scuffle. One guy, his name is Steve McRae, he sued his partner, which is now saying he wasn't his partner, but he sued his partner. He got a default judgment, and now the partner, his name is Kyle Curtis. Kyle Curtis has said that he wasn't served properly and asked for the default judgment to be set aside. So that's the procedural posture we're at now. So they are now putting in motions about the default judgment. So Kyle put in one motion before, then he got a lawyer. Now they put in another motion, and now Steve's attorney has responded to the attorney's motion. So that's what we're going to go through now. Jimmy Snow, you may be the only person worse at staying on topic than I am. Oh man, whatever, man. This is the atheist. Hey, listen,
I'm going to reimburse him. I'm going to reimburse him for 50%. He's totally right.
Thank you for the super chat. Yes, it's hard for me to stay on topic. So, with that said, $2.99 for Insidious Vids. Nate's Lamp and I are partners in perpetuity. My beautiful lamp. So, Nick, so
it's North Carolina. Your partners. It's a partnership by default. Please.
It's a partnership by default. So, listen. So, everyone, I always get complaints that I stop the flow of thoughts with super chat. So I'm not going to do that tonight. I'm going to be going back and forth through super chat. So I will not miss your super chat. If I do miss your super chat by any means, I will eventually respond to it tonight. But if I do miss it, please, I apologize, and just let me know at a later date. So without further ado, let's get to the filing. And Nick, have you read this filing, or are you reading it cold with me right now?
No, I've gone over it. I've gone over it a bit. I haven't really done I'd like to, an hour and a half sit down. I've been 10 or 15 minutes through it. I know roughly. I know the bullet points. I know, like I said, it's
We all right. So we're about to hit this right now hard. Hold on one second. Let me pull it up so we can all get to it. All right. So
I had it going. The other thing we could do is, well, now you can already see the live chat, but I was thinking people could tag me in it, and if they tag me, I'll try to kick it up and bring it up.
All right. Yeah. If there's a super chat, usually I can go back and get it. So, all right. So here we go. Let's see what's going on. All right. So this is Steve's newest filing. So Steve,
Yes,
so Steve, this is the response to the opposition of the defendant's amended motion to set aside the default judgment. Now, before we get into this, I want to say a couple of things. First, Steve's attorney has to get over what I like to call miracle work. This is miracle work he has to do. Why? Because he has to address a whole bunch of stuff, right? First, he has to address Steve's statements. Remember, Steve had the statement saying that Kyle moved, right? So he said that he knew Kyle moved. The second statement he has to kind of fix up is that he sent all the documents to Kyle's old address. So that's another thing Steve now has to fix. Steve's lawyer has to fix that in the filing, right? So he has to fix that in the filing. Another thing Steve's lawyer has to fix is that Kyle's mom signed for it. It wasn't Kyle who signed for it, it was Kyle's mom. So Steve has said that on camera, on video, and Steve's lawyer has to now address that in some way to make, to kind of lower that so it's not as damaging to the case. Also, he has to kind of address Kyle's evidence because Kyle has tax documents, bank statements, his mom's affidavit, his affidavit showing that he didn't live there, right? So he's kind of have to address that issue, and the fact that it was Kyle's old address. So his lawyer has a lot of work to do to at least give Steve a fighting chance to keep this default in order. What do you think about that, Nick?
No, I think that makes a lot of sense. So we've got and I just realized what the problem is. You'd think I'd have figured this out, and there are people who are going to laugh. I do voice dictation because I am dyslexic as fuck. But if I forget to turn it off because somebody spontaneously invites me into a stream, the windows start opening and closing. And I can't figure out why. It's because as I'm talking, the computer's trying to figure out what I want it to do. So I just got that off. I think you're right. I think what we've got is so Kyle's last motion. So he did his motion, then he did an update to it and he amended it, and I guess this is a response to that amendment, if I understand correctly.
Yes, but Kyle he's had two amendments, right? He amended the first. He had his motion, the first one he put it. Then he amended that, and then he hired the lawyer, and his lawyer amended the amended one. So
yes,
so we have a lot of amendments going on now. Steve responded to the Kyle's amended motion, and now he's responding to the amended motion. I know it sounds crazy, but that's where we're at. This is a crazy lawsuit. Give me a break.
And we'll have to. I think we're definitely going to have to talk about what does it mean to have service, because Kyle is now basically saying we have to start over because I wasn't served properly. We know his mother did get it. Obviously, that is a huge contention. Does his mother getting it count as service? It was, she's blood relative. Obviously, she's going to try to give it to him, I think you've discussed this before. I think this is going to be a big issue. Let's say he's got it. does the fact that he actually did in the end get it, does that still count as service?
Let's you know what? That's a great segue to the document.
Perfect.
So here we go. Plaintiff Steve McCray, through his undersigned counsel, submits this response to the opposition to defendant's amended motion to set aside the default judgment. So first thing he does is hit off with his objection and a motion to strike, right? The initial matter, plaintiff objects to defendant's amended motion and brief being procedurally improper. So here, I've already read this. What he's saying is that there's a rule in business court that does not let you contemplate amended motions, right? That the business court rules do not let you contemplate amended motions. And then he goes into how that at a minimum, the plaintiff's request that no further reply to the brief be permitted and that a hearing be held at the court earliest convenience. But one thing that he leaves out of here, Nick, when you see this paragraph, what don't you see?
Let's see. Objection.
It's something simple. There's no citation to any law, any rule, right?
Okay, so he's not, no precedent. He's not saying any. He's saying
what
these are the rules
about?
You have to follow, but he doesn't say either. He doesn't quote the rules, so he doesn't say like North Carolina Civil Code XYZ subparagraph J20. He doesn't cite that, and he doesn't cite the any precedent.
He's got business court rules, but what rule is he talking about? I don't know what he's talking about. Maybe somebody in his chat, if you know what he's talking about, let me know. Not saying that there's not an actual rule here.
Yeah.
But I don't know what rule he's talking about. He didn't cite any rule, right?
Well, it's incumbent upon you filing this to say what my suspicion is we're going to see later on a whole bunch of rules, and we're going to see a whole bunch of citations. He hasn't. That's odd. And I was going to ask you why would they even have this rule? Why would you not be able to amend it? And I could think of a few reasons, but we don't even know that they have that rule because he hasn't cited it, so we can't look it up.
It's just like, you know, he's just saying stuff like, yeah, there's a rule that says this. Okay, well, what rule are you talking about? I know nothing. Now, you know, maybe the judge knows what he's talking about. Maybe he's got ESP. I don't know. But at first glance, this may be great. Objection and motion to strike. If it's successful, it'll be great, but he cites no rules. So essentially, he's saying that he doesn't want Kyle to respond to this. And on top of that, he doesn't want the court to consider Kyle's lawyer's motion, but just to really work with Kyle's initial motion, the initial amended one, which is good because now, you know, he's punching down. I'd rather argue against Kyle than Kyle's attorney. Okay. No law, no citations. I don't know where he's getting these rules from. Okay, let's move past this.
Secret. I have to give you this one. Secret Squirrel. First rule of business court: we don't talk about business court.
Thank you, Secret Squirrel. Thank you for the $5 super chat. Dynamic White. So all the Biden supporters know, he picked a cop for VP. That's true. We got a problem with that because you don't forget they passed the crime bill to Dana. You're taking me off topic.
So I was just going to give you that Squirrel one because that wouldn't work later. That wouldn't have been funny later. That was just funny right then and there. That was perfect.
So the matter before the court remains largely as it was when the plaintiff filed the initial brief, right? So he's saying nothing's changed.
We do have one more legit question from Fiona Robertson.
Go ahead.
Good question. Do you recall any time that Steve has filed amendments in this? And I think he did. He filed an amendment because his very first when he filed his first motion, he did not under a penalty of perjury. He didn't actually get it notarized.
Yes,
and then he had to have it amended. So now isn't he arguing here? If you're not allowed to amend any filings, then wouldn't that invalidate? If he's right about that, wouldn't that invalidate his previous?
Well, to be fair, you usually now again, I don't practice in North Carolina, so take this for what it's worth. But generally, you can amend one time by right, and then and any other future amendment, you have to get them with leave of the court. The court has to say, okay, we're going to allow you to amend it. So so the First Amendment generally is okay. You know, because people make mistakes.
Perfect. Makes sense.
All right. So now we're moving to this matter before the court. So this is just the background stuff, right? This is what we've gone through before. So he kind of gives us some bullet points. Now, the good thing about these bullet points is that these are not in dispute. Kyle got, the summons complaint was served by certified mail August 30th, 2019. Certified signed receipt was signed by Susan Curtis. So these were the things I was talking about before. Susan Curtis signed. They sent it on August 30th. Defendant had lived at that address. So now they are now saying, now I think this is important because I think this is the lawyer just saying, okay, Steve has been out here screaming that Kyle moved, that it was his last own address. So we're just going to give it to him, right? Defendant lived, past tense, at the address with his mother at least through July 16th, 2019. So here it seems like they're admitting Kyle moved and his last day was July 16th and he was served a month and a half later. What do you think about that? Makes sense?
I would not give that date unless you're going to put your best foot forward. That's the best that they feel they can demonstrate. And if so, that seems to me an implicit acknowledgement that yes, they can't contest that he moved out the next day. They can't contest it.
Yes. Yeah. So they're saying we agree to this. Now, yep. The defendant does not deny that he actually received the summons and complaint. So they have Kyle Curtis's affidavit, Susan Curtis's affidavit, and Steve McRae's affidavit. So these are the four things that they say, okay, we agree to it, right? We're not going to fight you on these. You got the complaint, your mom signed for it, you lived there, you moved out on July 16th, and it was August 30th. So then they go into the legal standard. Now, the legal standard, they use this case called Granville Med v. Tipton. And they set out how service is established, right? The plaintiffs must file an affidavit. So they go through the process in establishing how service is done in North Carolina. So first, stating that the copy of the summons complaint was sent certified mail, sending a copy, all that great stuff. So now after you do that, the affidavit raises, when you finish that process, you get what they call the presumption of service. So you're presumed to have served the person properly. And that's the good thing about this. So the presumption of service with this is that after you follow these procedures, the person is presumed to have been served properly. And that's what they're talking about here. And this is where you see this last line. The presumption arises of whether the defendant signs the service of return or not. So they're saying that even if Kyle didn't sign it, right? Even though Kyle didn't sign it, the presumption is that he got it, right? So not just that he got it, but that
he got it correctly. So because I think we're gonna have to make a distinction between he got it properly, so he was actually properly served, and he got it as in he got his hands on it, right? Because those are two different, yeah.
But here it says the presumption arises regardless of whether he signed for the return of service or not. So whether he signed it or not is irrelevant. That's what this is trying to say.
Yes,
he got it.
Yeah.
And they use
the service is good. Yeah.
And where it says id, that just means look at the previous citation, which is Granville and Fender. Now I looked at both of those cases, and it's interesting because in Granville, so people can know what Granville, there was no challenge about where the document was sent. The challenge is that someone else signed for it other than the defendant. So that's Granville. So when they quote Granville is a case about there's no argument about where the documents went. The argument is about since the defendant didn't sign for it, somebody else signed for it, and whether that happened. And the same thing with Fender. Fender, it was a law firm, I believe it was. Yeah, it was a law firm, and the wife, she regularly signed for certified mail. So they sent it to the law firm. The wife signed for the certified mail, and that was considered good service because they said, well, hold on, your wife is an agent. She always signs for the mail. So in both of those cases, it went to places that nobody disputed were usual places, or the defendant didn't work there or live there. It was those were settled. It was about
it wasn't that issue.
It wasn't an issue, but the issue was whether the agent whether that agent actually gave the papers to the person, or whether, and so that was the issue in those cases, and that's what he's citing. Okay. So then he goes on to rebut the presumption. The defendant must present evidence that the service of process failed to accomplish the goal of providing defendant with notice of the suit, rather than simply questioning the role and identity of the person who signed delivery of the summons. So now they're saying that, hey, all right, you can't if I deliver it certified mail and the person signs for it, there's a presumption that you were served properly. And it's you need more than just saying, I don't know who got it. You need more than that to overcome that presumption. Am I explaining this well, or do you got
makes sense to me? Yeah. I think we're good.
All right. I hope I'm not boring everybody, but we're going line by line here. So the first argument. Now, I honestly think Steve's attorney has done something wonderful here. He's taken all of this junk and said, okay, I got a lot of bad facts. And what I mean by bad facts, Steve out here screaming, I sent it to the wrong address. Steve out here saying the mom signed for. He's got all those bad facts. And he's saying, well, how can I take those bad facts and make them into good facts for our side? And now this is some really, really great lawyering that the lawyer is going. You're going to see the lawyer is going to do to accomplish this, which is really good. And you got to give credit to where credit's due. If someone gives you lemons, this guy is trying to make lemonade, and this guy is making lemonade with this. So here we go. Let's look at our lemonade. So here, his first legal argument is the defendant failed to rebut the presumption. Defendant makes no attempt and does not contest the presumption of proper service. Rather, the defendant attempts to rebut the presumption based solely on the fact that he claims he no longer lived at his mother's house at the time of service was made. Okay, that's true, right? Kyle says, I just didn't live there. That contention. Now, this is where I'm talking about great lawyering. Taking a bad fact, because that's a bad fact for Steve and company. But he takes that bad fact and tries to make it a good fact for his side. That contention, even if true, is insufficient to rebut the presumption of proper service. So he's taking that bad fact and he's saying that, hey, this fact is horrible for us, but now it's good for us. And here's why. Great lawyering. I think this is what you want lawyers to do. I got bad facts. Let me see if I can find some law and make that bad fact into a good fact for my side. What do you think, Nick?
No, I think it's perfect. I think he's and he's also framing Kyle's argument. He's saying it honestly, which is the other thing. He's not trying to misrepresent what Kyle's saying. He's like, this is all Kyle's saying, and it doesn't address the presumption that he's been served correctly, which we are entitled to.
Yes. So again, I think this lawyer is walking. Now he's going to tell us a story. So now he's told us, right? So it's insufficient, and now he's going to go into his argument. So first, this is his first argument. First, as stated in Grantsville, defendant must show that service failed to accomplish the goal of providing him with notice of the lawsuit. Defendant never claims that he did not receive notice, which is true. And this is where I think great law and this is where I think great lawyering does come into play, is because when he says this, I just read it, where it says the defendant never claims that he did not receive notice. That goes to that. Remember that audio clip of Kyle saying the papers that I was served, He now has made that into an issue, right?
Yeah.
He now has made that into an issue that now that has become relevant, because before everybody was saying that's irrelevant, but now he's made that relevant, right? Well, here's the law, and he says that he got it. Boom. Changes the game. Again, taking a bad fact and making it into a good fact based on some legal precedent. Again, I know people are probably like, Nate, you're going crazy here, but no, but this is what lawyers got. This is the practice of law, taking shit and trying to turn it into cake. And this guy is baking a cake. That's what he's doing. What can I say?
Well, that's what somebody said earlier too. Somebody said neither of these guys deserve representation. I was like, look, you know what? They each have a side, a perspective. They of course somebody's going to represent them. And this guy's representing Steve. Kyle's got a lawyer representing. Let him. This is how it's fucking done. So this is how shoot each other. Yeah.
This is how the game is played.
And so if you want to know the best cake baker I've ever met, that man right there. He can bake a cake, man. Boy, can he bake you 16 layers. You're sitting there going, I don't even know where to begin to dive into that one.
Oh man. Oh yeah. But again, he has a client who's said all this, who's kind of boxed into a hole, and he said, you know what? I'm going to take these lemons and we're going to fucking make some lemonade. So here we go. So now he says, okay, so none of the affidavits submitted claim that he did not receive notice. Again, absolutely true. As in Granville, the allegations that he failed to receive the summons and notice of the suit is conspicuously absent. Now, this, I think, is, again, good lawyering. Why? Because he's making the argument that Kyle's mom is Kyle's agent. And in Granville and on all these cases, agent cases, I like to call them agent cases, the issue is that if I deliver the papers to your agent and I can then prove you eventually got the papers, that's relevant. So, and that's what happened in Granville. I showed that I delivered to his agent, and then in Granville, they were able to show that the agent delivered it to the defendant. And that's what Kyle's lawyer is doing. He's doing the same exact thing. Beautiful, beautiful, beautiful. Saying, hey, Kyle's mom is, and then the great part about it is that it undercuts Kyle's argument, because don't forget, Kyle's affidavits never says that his mom is not his agent, right? None of Kyle's affidavits say his mom is not his agent. So that's what they're attacking. Kyle's, they've never said that. So we're saying that, yes, the presumption for us is we delivered it to Kyle's last known address. His mom signed for it. So the presumption is she is his agent. And here's the case law, Granville. Thank you, Nervy, for the super chat. $5 from Nervy, uncivil raid. So this is taking those lemons and making that lemonade. Go ahead, Nick.
Well, I notice here, all of a sudden now we've got and I'm looking just at the next couple lines. Now we got citations. We've got, here's the law. Here's the, all of this. Dead absent in the first paragraph.
More so, here it is. More so over, because now you're saying the mom's an agent. So now, moreover, the defendant acknowledges that he had notice in various internet forums, including those identified in the plaintiff's initial affidavit. So there you go. So now all those recordings, every time he goes on the show, every time Kyle talks, he's saying that he got notice, right? So his mom was his agent. We delivered it to his agent, and his agent gave it to him. And how can we prove that? Because he said it. Brilliant, right? Taking those lemons, we're baking that cake.
Nate, why don't you and this lawyer get a room? Just get a room.
No, but you know what I appreciate? I appreciate that this lawyer has a tough ass job. This is a tough job. This is a tough job. And I was sitting back here thinking, how the hell is he going to do this? How the hell is he going to make this shit smell like shit? And this is a hell of a job, not making it smell like shit. You know what I'm saying? You get me?
It's what every lawyer has to do.
Now, Nick. Now, just to be just so everybody knows, Nick is a famous author. Nick is on this side, right? Yeah, Nick is a famous author. So, Nick, you've read a book and you be like, "Well, damn, that's a very well written book." Like, has that ever happened to you before? And you can appreciate the talent.
No, absolutely, and crafting anything, crafting a book, crafting and one of the reasons my BA was in philosophy, and I actually got the award for mock trial because I did teach. I'm a coach for Massachusetts mock trial. I'm a Mass Bar certified coach for that. So I love those arguments. I love doing it. Obviously, I don't have any of the training, which means I get to actually give legal advice without risk of losing my license.
Right. and with that said, thank you so much. This is not legal advice. If you're looking at this stream saying this is legal advice, you're on the wrong channel. This is not legal advice. Pretend I am not a lawyer. Matter of fact, there's a whole bunch of people out there saying that right now. Believe them, because this is not legal advice. Let's go with that. All right, so back to the document.
Yes, sir.
So here we go. So now we're into his second argument. It is insufficient to simply argue that the defendant's mother was not authorized to accept service. Defendant apparently contends that because he no longer lived there, his mother was not authorized to accept service. But now they go back to Granville. It is insufficient to rebut the presumption of proper service simply by questioning the role or identity of the person who signed the liberty. Now, this is where, again, he's turning shit to cake. Conspicuously absent from the defendant's affidavit is any allegation that the defendant's mother was what? Not authorized to sign for the certified mail addressed to the defendant. Again, now Kyle, and if you think about how he's trying to set this up, which I think is brilliant. Earlier, he said they shouldn't be allowed to respond to this, right? Because if they're allowed to respond to this, what's Kyle going to do? He's going to have things go in saying, of course, she wasn't my agent. So he's saying, well, first, I don't want them to be able to respond to this because they've responded too much. And second, in everything that they've already responded so far, they never even said that she wasn't the agent, that she wasn't authorized. And the presumption, and we have that presumption. Again, taking those lemons and making lemonade. Let us move on. So then he says his third argument. Assuming it is true that the defendant did not live there on August 30th, 2019. So now this is the big thing, right? This is the big thing everybody's saying. He's saying, okay, so even if it's true that he didn't live there when service was made, that is not enough to rebut the presumption. Defendant apparently contends that service by certified mail must be made to an address where he pays rent, receives mail, or has reported to an employer to his residence. So he takes all of Kyle's evidence and says, this is what he contends, right? But plaintiff cites no case or law. Plaintiff cites no case law or statute supporting this allegation required. So he's attacking Kyle's evidence straight up. Okay, Kyle has submitted all this evidence, but he has nothing here to prove that it's even that's even good enough to show that he wasn't served properly. What do you think about this?
I'm going to disagree because he does cite one law. He cites one statute. He cites it was rule. Oh dear Lord, let me look it up because I happen to have
Rule
here.
60, I think it's rule 60 or one of the two.
4J J2 sub 2, which he cites, and that I think will become relevant later. But I think the lawyer's done a great job of accurately representing everything Kyle's saying, accurately representing his claims, and then so this is how we're going to deal with those claims. Until now, this I disagree with because he did cite one, and I think, as I recall, he also cited some case law. But at a minimum, I know for a fact he did cite one statute, and I think that's relevant.
And I think everybody, it's important for everybody to know. Steve's lawyer isn't arguing against Kyle's lawyer's last motion. He's arguing against Kyle's initial motion, right? He's saying that the last motion that Kyle put in shouldn't even be. So he's arguing against Kyle's initial motions. He's not arguing at the last, because the last motion obviously had much case law in it. So, and he's arguing against the evidence that Kyle has provided. So it's an interesting little twist. He's trying to walk the fine line.
There's a good point. You don't want to be litigated to death. You don't want someone to just keep updating the motions and amending these things forever until everybody keeps replying. So I understand that makes a lot of sense. Where there's a limited number how you can, but that does mean that Kyle would still actually have a bite at the apple. He could still ask the judge to accept his. Could he do that?
He can ask for. He could
still do that. He hasn't. So it hasn't been rejected. It just hasn't been accepted. At least assuming that it operates the way you said it does. You don't know because you're not from North Carolina, but you just said typically this is how it tends to be. So assuming North Carolina law is relevant, that makes sense.
Yeah. So third. So now we're into this third argument. So plaintiff cite no case law. Now he goes to this, even assuming again that the defendant's affidavit is true and that he received mail in the shovel, this does not preclude him from service. Now, this is where things start getting a little. Now, this is where I think he starts jumping off the rails a little bit. He says in a different Rule 4 context, courts have found that the defendant may have more than one location where they can be served. And he quotes this: "It is unrealistic to interpret Rule 4 that the person to be served only has one dwelling or usual place of abode, which process may be left." So in other words, he's saying that Kyle is saying I only have one dwelling or place of abode, but he cites this case that says, hey, you could have more. But I looked it up. Now, obviously, I'm a nerd and I looked these things up. So let me show you what I found, because I looked up this citation. And when I looked at this citation, it was something very interesting I found. Let me see if the Van Buren citation is Van Buren. He cites.
Well, and I already have one objection too, and I'm curious to know if your objection is the same as mine.
Now, in Van Buren, it says this about, because again, a lot of times these cases come down to finding what the hell is your usual place of abode. What the hell is that, right? So in Kyle's, so I got this from Steve's motion. This is what it says. Let me see if I can highlight it so you guys can follow what I'm going to read. It says the decision interpreting the term indicates that no hard and fast definition can be laid down, but that what is or is not a party's dwelling or usual place of abode within the meaning of the rule or statute is a question to be determined at the facts of the particular case. So the court is saying that there is no real hard and fast rule about what is your sorry, I should have put this up, but what is your usual place of abode? There's no hard and fast rule. It is a fact specific inquiry. So every case that you get, you have to determine whether this is the person's dwelling house or usual place of abode based on the facts of that particular case. And that's the case that he's citing. So it's possible you can have more than one, yes, but there is no hard and fast rule. And I think Steve's attorney is trying to make it seem like there's a hard and fast rule. What was your objection?
Roughly the same. It's a little different. Okay, so it says it's unrealistic to determine Rule 4 so that a person may only be served at one address. So the way I look at that is you can't sit there and say that because of the way Rule 4, which I have no doubt we're going to get into, the way it's laid out, there's only one place a person could possibly live and you must serve. No, if somebody's a rich Tom Cruise, you like to use him a lot. Yeah. If he's got six homes, they all count. Any one of them counts, and Tom Cruise can't sit there and say, well, yeah, that's my summer home. Yeah. But just because it's possible that someone can be served at more than one address, let me rephrase that. Just because it's possible that somebody has more than one home, and you can't use Rule 4 a defendant can't use Rule 4 to say, well, only one of those is my house, and you just happen to hit the wrong one. It doesn't go from that to say that necessarily anybody can be served anywhere, or that any other place is necessarily a dwelling. So that doesn't get you to this was a dwelling. You have to. He has to have been. My understanding of Rule 4, he has to have been living at his mother's house. Just because this rule allows for him to have multiple places, unless you establish that his mother's house was one of them. And just because he'd been living there a month prior, from what I can tell, he wasn't getting mail there. He was paying electric. He was doing all this other stuff at this other place. I think that's the bridge for me. That's difficult to jump.
Well, let's see how Steve's attorney seems to answer this. He said, right. So we were at, let me make sure I didn't lose my place. We read this. Yes, we read the citation. All right. So if the defendant no longer wanted to receive, so this is what he goes, the nothing. All right, so here goes. Here, the defendant had previously lived with his mother and had apparently done nothing to change his address with the post office. That's not that you got, like, you have to show some legal citation for it. Like in other words, that he had to change his address to the post office. I've never changed my address to the post office. I don't know if anybody out there in the chat has changed the address to the post office. I don't think there's any requirement, but I think he's putting that he's trying to build a narrative, right? He didn't change his address to the post office. He could still receive mail at his mother's house, which is true.
Yep.
She was therefore authorized to accept service of process. That's the issue the court's going to have to decide. Now, if the defendant no longer wanted to receive mail at his mother's house, he could have simply changed his address with the post office. Now, I don't think I understand what he's trying to do. Is to say, until you move until you change your address at the post office, you still live there. That's just not how it works. When you move, you move. And it says, which would in turn have provided notice to the plaintiff so that he could have sent it to so that service could be sent to the forwarding address. So in other words, he's saying that it's Kyle's responsibility to go to the post office, give a forwarding address. So the plaintiff, this is all BS. I'm just going to call it out. It's just all BS. There's no requirement in law. He cites there's no law here. He cites, it's just, this is just argument. There's no precedent here. Go ahead, Nick.
Well, no, yeah, no. I was impressed. Usually you're giving as much credit as possible here. Like, nope, it's BS. And I see there isn't any. And there again, we get back to what they said earlier. There's no hard and fast rules about how you know where he lives, except that I do recall reading somewhere, I don't remember where, that if he's paid a utility bill somewhere, you can say that is an address. Again, Rule 4 doesn't limit you to one address, but the question is, what's reasonable in terms of him living at his
mom's address?
Yeah, that's a tough question.
It is tough. It is tough. And again, I think he's taking that shit and turning it into pound cake. He's pounding it away now, pounding it away. So he puts or Mr. Curtis.
I'm really not going to go there. I just had a joke I really just decided to stay away from. Please continue.
Now it says, or Miss Curtis could have refused to sign the certified mail when it arrived, which also would also have served to notify the plaintiff. Instead, defendant did nothing, boasting about doing nothing publicly on YouTube, filing nothing until February 6, 2020, 5 months after he had received the summons and complaint at his mother's residence. So now this is the kind of like, yo, he's got all this stuff. He's not doing anything. He's just wasted our time. So he should not be rewarded for this. So now he goes into B, case law addressing service by certified mail on an individual that provides actual notice to the defendant clearly favors holding that service was proper. Then he goes in this. Now I'm just going to read this straight, right? Most cases cited by the defendant concern service in the matters other than the certified mail. Defendant cites no case where an individual defendant was served certified mail, presumption of service under rule. So he goes into presumption. By contrast, North Carolina courts have held that service was proper when the defendant was served by certified mail, the presumption of service. So he's going into the presumption, and he gives one thing. He says, for example, Granville. This case discussed extensively above, the defendant was served by certified mail and the affidavit of service was filed. And the court found the presumption of service was raised. True. There was a presumption of service because they did it through certified mail. Defendant attempted to rebut the service by saying a couple of things. That he did not sign for the receipt personally. That's what Kyle is saying. The receipt was signed by someone named Hodgepeth, which is signed by Kyle's mother. You could just switch that out. And the defendant had never employed anyone named Hodgepeth to sign as a principal officer, right? The court found that this did not matter because the critical issue was whether or not the defendant in fact received the summons. But I think here is where he tries to now turn the shit into pound cake and forgot that it's shit. and the reason why I say that is because the issue in Granville, the issue wasn't that he sent it to someplace else. Because that's the issue here. Kyle is saying he didn't send it to my dwelling or house or usual place of abode. And in Granville, that was the issue, right? That wasn't an issue.
Yeah.
There wasn't an issue that he didn't send it to the usual place of abode. That was the issue. The issue, it's like saying in Granville, they sent it to his house, but here Kyle is saying they didn't send it to my house. So I think that the case law just doesn't match up because that's a very, very, very critical piece. What do you think, Nick?
So in Granville, they were arguing that the person wasn't an agent, but it was the right address. Here, we're arguing we're not arguing about the agent, or at least Kyle's not arguing about the agent. They're arguing about the address. Correct. And so it's one can see why someone might snag that case as a citation, but the reality is it's a different claim being made by Mr. Curtis at this point.
Yes.
Right.
Yes. So, and then he puts, the defendant has failed to rebut the presumption of service, so the motion should be denied. Then he goes into similarly and felt the defendant was served by certified mail. And again, this was the same thing. Again, and this was, again, it was served at the place where he worked. It was given to his wife, who always did. So this was different because this didn't challenge that it didn't go to his home his dwelling or usual place of abode. This was challenging the fact that the defendant didn't sign for it. It went to someone else. And if that person was an agent, and the court said, well, the presumption was she was an agent and you didn't overcome the presumption that this person was an agent. Does that make sense?
Yep. Which now, again, no, it's not about an agency here. It's about the address.
Well, Steve's attorney has made it about the agency, has said, okay, Kyle's mom was an agent. And the presumption is that she was an agent. And Kyle hasn't said that she wasn't an agent. And Kyle, so he's saying that we sent it to Kyle's mom. She was Kyle's agent, right? Kyle hasn't rebutted that presumption. He hasn't said she wasn't an agent. And the fact that he did get it, right? And all of these cases said, if you send it to an agent and we can prove that Kyle actually got it, he can't overcome that presumption. Service is good. What do you think about that argument?
I think it's going to hinge on, is it all right if I just quickly go into, so this is 4J2 sub 2. So this is North Carolina. These are the regulations regarding service. And I find it's interesting. There's an or there that I think may get things interesting. So J2 is proof of service. So this is And then subparagraph 2, register certified mail. It has to be sent to the person. The affidavit, together with the return receipt copy, postal service. Now, if the delivery is not to the addressee, but is to a person, you have signed receipt, and the person was an agent of the addressee authorized by appointment or by law to be served. His mother, I can't believe, was authorized by appointment.
But the thing is that when she signed for it, the presumption is she was an agent. Okay. Now let me show you some case law, because there's a case. Now, before you go on, there's a case. Please. There's a case here that I think is on point, and I'm going to ask the people in the chat now. Before, listen to this case. Listen to this case law, and I want you guys to really to see whether this case is on point against Steve's whole argument. Now check this out. This is a case. This is called Osman v. Where's it at? I had it up. Osman v. Reese. I pulled up this. I got to pull up the case. I got to pull up this case, Osman v. Reese. Now, in this case, almost the identical facts happened. Almost these identical facts happened. And it's actually pretty stunning that it's here that I found this case. It's kind of crazy. Okay. So bear with me. Let me make sure I got the right spot. All right. So this is an Osman. Now, there is no dispute that the plaintiff did not serve the defendant at his dwelling or usual place of abode. Now, I'll say, let's assume that's true here, because Kyle has all this evidence that he didn't live at his mom's house, right? So we're assuming this is true. Now, in this case, the merchant tire is where this guy worked, and Reese presented 2 affidavits, right? So the company and the person who was trying to be served, right? The defendant presented 2 affidavits stating that the person who got the permit, his name is Stack, was not an agent of Reese authorized to accept service on Reese's behalf. So that's the first thing that Kyle needs to do, right? He needs to go and get his mom to give an affidavit. She wasn't, and then he needs to sign an affidavit. She was not authorized to serve him on behalf, right? Now, so you have 2 things that line up. It wasn't his usual place of abode, and someone else signed for it, right? It wasn't him. It was someone who was of suitable age and discretion. It is the province of the trial court to make credible determinations upon the evidence before it. There is credible evidence to support the trial court's finding, in turn, that the trial court's finding that fact of support is conclusions of law and order. So in other words, they're saying those 2 facts are good enough, right? That he didn't live there, and the person that they sent the paperwork to was not his agent. So then, in Steve's motion, he makes actually a secondary argument. And let me bring this up. This is the problem when you're doing all this legal stuff, because you got to go back and forth through documents, and these things aren't very friendly to go back and forth through documents. So Steve's lawyer makes this argument. Where's it at? Defendant treated this, so that's him pearl clutching. It says the presumption held. Let me see that. Where's the end? All right, conclusion. Steve's lawyer makes the argument that Steve's lawyer makes the argument that Kyle, since he actually got the papers, right? Yep. That he has been served. So the clear weight of evidence. Where's it at? I just had it. Now I'm searching for it. All right. Yeah, here it is. So Steve's lawyer is making the argument that case law addressing service by certified mail, an individual defendant that provides actual notice to the defendant clearly favors holding that service was proper, right? So Steve's lawyer is saying that the case law and everything says that if Kyle had actual notice, it favors holding that service was proper. Now, back to the other case. Sorry about this, guys. I know this is crazy, but this is important, because this is actually
this is critical.
Yeah, this is a critical point in this case. So, remember what I just said. Steve's lawyer is saying Kyle had actual notice, and that is what makes this good, even if everything else is bad. Now, this is what the Court of Appeals in North Carolina says in 2010. Plaintiff further argues that even if service was insufficient pursuant to Rule 4, Reese had, what does it say here?
had actual notice and therefore could not rebut the assumption of service, which is to say that he did somehow get his hand on the papers, so he can't rebut it.
So this is this is Steve's lawyer's argument. Am I wrong?
No, that's exactly what he's saying.
Let's see what the court says.
Oh, they say because that's what. Okay, so there's
Hold on, I
there's
haven't
recordings.
finished.
Yeah, there's recordings.
Yes.
Yeah.
So it says plaintiff relies on our court's opinion in what case?
Granville. That's the same one we've been using. Both of them. Yeah.
To do what? To support her argument.
So this is another case using the same citation
same exact
of law.
Argument. The same citation, argument. The same arguments. And it says, however, in both Granville and Fender, our court considered actual notice in reading its determination that the presumption of proper service had been established by plaintiffs, and then made the subsequent determination that the defendants had failed to rebut the presumption. But based upon the findings that the defendant had failed to rebut the presumption of proper service, our court in both Granville and Fender held that proper service of process had been accomplished. But here it is. Neither Granville or Fender stands for the proposition that as long as Reese had actual notice, improper service on Reese would vest the trial court with personal jurisdiction. Quote, while a defective service of process may give the defending party sufficient and actual notice of the proceedings, such actual notice does not give the court jurisdiction over the party. Citation. Boom.
Okay, so what if I understand this correctly? What this is saying by jurisdiction over the party, what they really mean is the service. The yes. Service has been done.
They're saying that Steve's lawyer's argument is junk.
Well, they're saying they're saying that the cases that he's using cannot be pressed into saying that just because Kyle had the documents and admitted to having the documents, that constitutes proper service. But both of those cases, is that how he's trying? I forget. Is that how he's trying to press that? Yeah. What was the?
Yes, Steve's lawyer is trying to press that. Hey, both Granville and Fender, as he said, stand for the proposition that actual notice is good enough for service. But here they're saying, no, that's not what they stand for. Matter of fact, they outright reject that. They said, no, it says the defending party that even though defective service, which we have here, which looks like, may give the defending party sufficient and actual notice of the proceedings, such actual notice does not give the court jurisdiction, meaning authority, over the party. And that's what they're saying, proper service. Absent valid service of the court does not acquire personal jurisdiction, and the action must be dismissed. And at the end of it, it says this argument is without merit.
Okay, but what they're pressing it into, because I'm looking at it here. Second, it is insufficient to simply argue that the defendant's mother was not authorized to accept service for him. Defendant apparently contends that because he no longer lives with her, his mother was not authorized. But as stated in Granville, it is insufficient to rebut the presumption of proper service because simply by, quote, questioning the identity, role, or authority of a person who signed for and delivered the summons. So it sounds to me like, at least in that case, they're using this not to say, hey, he got a hold of it, but saying that the identity is not sufficient. Am I misunderstanding that?
Yes, because he's making three arguments, and here's I'll put it on the screen now.
Perfect.
CB, he says, case law addressing service and certified mail on an individual defendant that provides actual notice to the defendant clearly favors holding that service was proper. Right?
Mm-hmm.
That's what he's saying. And then he goes through it, and then he cites, for example, Granville, right?
Yep.
That's what he said. For example, Granville, and he goes and he explains Granville, and then he says, similarly, and Fender.
Okay. Yep.
And then now I'm going to show you the court looked at those cases and said, well, you know what? Let's look at those cases, and in this case in Osman, the court said, no, that's not what they stand for. Matter of fact, they don't stand for that, and this argument is meritless because it says that this in Granville, and it's saying that the plaintiff relies on that court's opinion in Granville, right? And Fender,
yes.
Again,
yep. It's
to support our argument. How both Granville, the court considered actual notice in reaching this determination that presumption of service had been established by the plaintiffs. But at the end, it says this argument is without merit.
Yes. Okay, that makes sense, but that's still limited in scope specifically to he had the documents, so proper service, right? That doesn't apply to
it just wiped out the whole argument that because he had actual notice of the lawsuit, that he was served properly. That effectively wipes it out. But it only in that limited way where if they say that it is a if it wipes it out, except in the way if the presumption is that Kyle's mom is his agent, which I think Kyle's going to, obviously they're going to just take care of that. But if they can say Kyle's mom was the agent, then this whole actual notice thing matters. It matters then because now your agent actually gave it to you. But if if Kyle's mom is not an agent, then you can't use this. This is a meritless argument. That's where it comes, and that's what Steve's lawyer is relying on. It's relying on these two cases. Does that make sense?
It makes perfect sense. So there's more than one argument being made. They're making lots of different arguments, and you have to figure out what evidence is being applied to what argument, sort of what's the sum total of what they're. So it looks to me at a minimum like the whole idea that, well, hey, he said he had it. Ergo, it looks like everything they have for that it has actually been tried before and failed to be pressed into that service. Now, I think in that case that you had said, they actually did find that the service had been valid, but for other reasons. And they said, you cannot use these cases this way, which appears to be exactly what they've decided to do.
Yes. All right. Yes. So
he can be taught, folks. He can be.
So, you know what? So at the end of the day, I think now the personally, the two issues I think now that are going to judge has to decide. Number one, was Kyle's mom his agent?
Yep.
Could you make that argument? Because don't forget, in all these agent cases, it actually went to the person's dwelling or usual place of abode. Here it did. But can they make the argument that Kyle's mom was his agent? And can they make the argument that it didn't have to go to Kyle's dwelling or usual place of, or that Kyle's mom's home was his usual place of abode? It seems like that's what they're trying to do. And the last piece of it I want to let everyone know is Steve has to win. Kyle wins the tie based on the fact that the court favors setting aside default judgments. Yes. Kyle wins a tie.
Well,
now, go ahead.
Just because I want to make it clear, because you had said this before, but I just want to, because I think this is really important. So, yes, there's a presumption of service, which we've already talked about, but this is a default judgment case, and judges in general don't like default judgment cases. They don't like having people win by default. It does happen. It has to happen, but they would rather not. So what it sounds to me like you're saying is, hey, if the judge has an out to say we're going to try this thing for real, he's going to take it. So if there's a tie, he's going to say it goes to Kyle, so we throw it out. That sounds like that's what you're saying.
Yes. Matter of fact, I even have it right here. This is Kyle's lawyer's motion, and it says, and she actually puts the legal standard here. It says for good cause. Where is it at? I'm trying to see. Defendant relied, effective service. Trying to speed read this, but I saw it here. She has a standard in here. Renewed motion. No. But the standard generally is, why can't I find it? Introduction. But the legal standard generally is that the defendant wins a tie. So if you can't, if it's so muddy and so crazy, then the court's gonna rather would overturn a default judgment in favor. Oh, here it is. And she gives us a thus. Any doubt should be resolved in favor of setting aside entry for default judgment. And she puts it, the provisions for setting aside a default judgment are true liberally to give litigants an opportunity to have the case disposed of on the merits. She gives the citation, and then she said, thus, any doubt should be resolved in favor of setting aside the default judgment. So this is saying Kyle wins a tie. And she has 3 cases that cite that. So Kyle wins a tie. So Steve has to win. Kyle wins a tie. Go ahead.
No, I was going to opine on the fact that, I mean, the other thing is, And I think you and I maybe discussed this before, but just in terms of the culture of the courts and stuff like that, because somebody was opining in the live chat earlier, they're like, well, the judge is going to want to get this done quick and get this taken care of. Two things. This is in a mandatory complex business court that handles millions of dollars in cases. So this is not high on their priority list. And there's the fuckery clause sort of at the end there, where it's just like he's accusing Kyle of messing with things, but I can see the judge thinking Steve's doing the same thing, and so the judge, I would imagine, you have much more experience with judges than I do, except for just that few times, but I was on the wrong side of the experience of the judge. At any rate, the judges would much rather. Yeah, they want to get things through the court system as quickly as possible, but the best way to do that is keep people out of court. And so what they do is they say, you guys figure out a way to solve this. And if you're going to be screwing around with each other, I'm just going to, in my view, having them start over is a big plus, so that they just both sit and come to the table and say, none of us want to do this again. And that's incentivized if the judge says, hey, done. Let's start over. And I'm not saying this because it's fair or because of anything else, but just in terms of a judge and how he's thinking, I think he's got to say, you guys, you're a bunch of YouTubers, had no contract. You just sat down and you're just like, hey, dude, let's start a show. Whoa, it took off. You're out. No, you're out. No, I'm going to destroy the. And the judge is like, listen, I got $20 million. And I've heard on both sides. I've heard people say the judge is going to be so mad at the other person. The judge doesn't give a fuck. The judge wants this done. So the judge says, am I right about that, or am I? Just
You're right. You're right. And the interesting part about this is that I don't know how this is going to go. Right? Who knows? Who knows? Yeah. But the fact of the matter is that now we all have the facts. Right? We have Steve's lawyer has tried to, I think, make an excellent argument based on the shit he has, because Steve has put him in a very precarious position. Right? He knows that video is going to be played of him saying, we know he sent it to the wrong address. He knows he's going into a hearing, that's going to be smacked in his face, right?
In the same way that they're saying they're sending out the videos of Kyle saying like, exactly. Oh, I had service. They're both. Of course, they're going to do that.
But the I think the issue here is that which is going to hurt more? Is Kyle saying I got served going to hurt more, or is Steve saying I sent it to the wrong address? Is that going to hurt more? Here, to me, it seems like Steve's admission is going to hurt more. And he's trying to mitigate that. And I think he's done a great job of trying to mitigate that. But I just don't think he has the law on his side. Because that case, the Osman case, really, really, really lays out that no, the law is not on your side on this one. So with that said, if you guys want, let me just go over the last, to be fair, so we can see Steve's lawyer pearl clutch a little bit. Now,
this is the fuckery clause. Yes, I
it's now the last part of this is I think is unnecessary, but everybody has to prosecute their own case. Defendant has treated this and continues to treat the lawsuit as a child's game. He's got a lawyer. They filed a professional brief. I don't know how he's saying this. So now he's saying it is indispensable the defendant had notice of the lawsuit and simply chose not to respond. Again, all the legal citations saying that notice, just because he had notice doesn't mean anything about proper service. So, and now he does a whole bunch of pearl clutching, about, he's such a bad guy. He's still quoting Granville again. Again, if I'm showing Osman. Now, Osman, though, I will say it's an unpublished case, so it's not that type of precedent. It's not binding precedent. It's persuasive, but I think it's good enough where you can throw it to the court and say, hey, listen, we got a problem. So then he does a little bit more curl punching. Here's a parent defendant knew of the lawsuit, but again, that doesn't matter. It's about proper service. Ignored his obligations. True. And flaunted his default. However, the defendant has used this matter and delays brought by the pandemic to play games. All this is unnecessary, and what this to me shows, when you don't have the law on your side, you bang the table. And he's banging the table here, right? I don't have the law. I don't have the arguments. Let me bang the table a little bit. And I think he could have done I think if he'd have left it at the legal arguments, you get a better fighting shot. But now just banging the table doesn't mean anything. The court reminded the defendant about following the order, he disregarded the court's order. But again, the order is no good if he doesn't get if the default is thrown out.
That's a gamble, though. That's a gamble, though, isn't it? I mean,
it is a hell of a gamble.
Let's assume it doesn't get thrown out. He is now in contempt.
It's a hell of a gamble.
Wow. He. Woo! I'm impressed. There's some cojones there. Okay.
And look, he puts finally setting aside the default judgment, reward the defendant for his behavior while severely prejudicing the plaintiff. So, again, I think a lot of this, the end is just, oh my God, he's such a bad guy. But if the legal arguments aren't there, they're just not there. Conclusion: the defendant has failed to rebut the presumption of service, which I think he has. Therefore, the defendant's motion to set aside the default judgment should be denied.
This reminds me. Teachers bringing their kids to court, just so the kids can see the thing, and the judge says, "Oh, hi, I'm the judge. That here is the prosecutor, and that guy over there is a murderer." And I object, Your Honor. I can't believe you've already said you've made up your mind that my client is guilty and that he's guilty of murder. You have to recuse yourself, and we're going to send a letter to the. And the judge goes, and that is the murderer's lawyer.
Oh my God! Well, hey, listen, but the one. All right, so. Two things. Let me read these super chats since we got a little break. Secret Squirrel says, when do we get to the part Kyle has precognition about COVID? Secret Squirrel, you're killing me. Thanks for the $5. In War of the Roses, hated each other. Shared a house while splitting. I don't think Kathleen Turner would have given Michael Douglas a certified letter in the case like that. Married, so each other's agents. Married, so each other's agents. I don't know if Kyle and his mom are married. I don't know.
I think what he's claiming is that Steve and Kyle are married.
Interesting. August, I read this, but I don't understand it.
Even though they hated each other. Okay, in War of the Roses, it's a movie.
I know War of the Roses.
Oh, okay, yeah. So they hate each other, and then so he's asking is, at what point does someone stop becoming an agent? So presumably when they're happy with each other, living in the same house, they're each agent for each other because they're married. If they want to certifiably murder each other, are they still agents? And I imagine that's a case by case basis. Yeah.
See, I'm thinking the agent. Now again, I'm not versed in North Carolina law. I think the agent argument is a really, really good argument, though. I got to give it to you. I think the agent argument could be a winner because you could say, well, hey, his mom was his agent. He's never said she wasn't an agent. We have the presumption, right? Because someone else signed for it that she was the agent. So now, and on top of that, we don't want them to even respond to this, right? Because they've already responded enough. How many times they're going to respond? So I think so if people walk out of here thinking that this is a loser, that may not be that may not be true. This could win.
I'm going to hold you to before this is over, before this stream is over.
Mm-hmm.
Just you and I, just like off the record. Forget there's an audience or anything. Just your over under on off the record what you think, because I'm still every time I talk to one person or another, it's like, that's a good point. I haven't decided yet whether I'm still 50-50 on whether the service this issue is going to go.
All right, what do I think? Well, two things. Number one, I think from all the case law, right?
Mm-hmm.
Kyle's mom wasn't his agent. He sent it to Kyle's old address. He knew it was Kyle's old address. If the court accepts the argument that Kyle's mom is an agent, Steve wins. If the court doesn't accept that, Steve loses. I think that's what it's going to come down to. Was Kyle's mom his agent?
But he hasn't questioned that, really, has he? He hasn't actually assaulted that. He's gone after the address, but he hasn't gone after the agent. If he can't amend that, or does he get to go after that later?
Well, if he can't amend that, then I think then at the hearing he's got to attack. There's going to be a hearing, so there's going to be a hearing.
Perfect.
But that's what it seems like it's going to come down to. Was Kyle's mom made? Because I think Kyle has overcome the presumption that he didn't live there. And for those of you who want to know how to do that, I have the case law right here queued up, so we'll go. Let me just do a super chat, and we'll look at how you overcome the presumption of that you didn't live there. So seriously, Nate. I've been servicing Steve's mom for 2 days. I need $5 in legal advice. How much longer till it's considered proper service? My mouth's so dry. Oh my God. Pirates of the Deep.
Hold
You made me read that. You made me
hold
read
on a
that
sec.
now.
Oh, wait. Oh, I'm sorry. I'm getting Nate the lawyer demonetized. Oh, sorry.
Oh my God.
YouTube. I think that was sent to the wrong phone there. Okay.
I think that's why he sent me the $10. Think of it, a $10 super chat. He's like, yo, this is definitely
need to
gonna be
make up for
demonetized. So he's gonna read this. Watch, he's gonna read this. Damn you, pirates! It's good to see you again, too, pirates. Pirates is cool. Pirates is always around. I love my secret squirrel. Secret squirrel, I see you in there. So let me show you guys this last piece of case law, because you guys love case law. Before we get out of here, this is the case of, is it Gibby? It's funny now. I feel like I'm gonna go and take the bar in in North Carolina.
There was one other question I wanted to ask, because we've been talking in the live chat, and somebody brought this up anyway. But we've been talking now. It was the Chief Justice of the North Carolina Supreme Court who said that this was a business, and it got sent to the Mandatory Complex Court after that designation. There is where now they've been having was the service necessary before that designation or after the designation? And if the service is found to be bad, do they lose that designation and have to start that over? Because with that designation, at least right now, presumably it is A, business, and B, a 50-50 partnership, which is, I kept using the term default, and they're like, no, Nick, the defaults get thrown out. No, I mean de facto. It's a de facto. It starts out as a North Carolina law. It's a 50-50 partnership.
Well, the first thing is, now again, I hate fact I have to keep saying this. I'm not a North Carolina attorney, so again, take this as a layman who's just read some stuff, and I think I know what I'm talking about. That's how you should be taking this. This is not legal advice. But the way I'm reading it is that in North Carolina, you have a partnership kind of by, in fact, if me and you get together and fix up a car, we have no paperwork, we have nothing. The courts will consider that to be a partnership, right? Because they'll look at the facts and circumstances around this. You guys are so we would probably go to mandatory business court if I sue you saying that we were in a partnership, that type of thing. So it's kind of like when you have cases like that where you have business relationships, even those that are not formalized, like this one wasn't formalized, that is considered a business. But now about the 50-50 piece, that's part of litigation. That's something that has to be found in fact. But I think just with the complex business court, was this a business? If you can prove that we have our disagreement is about a business, about particularly some type of business, then you go here because these are the experts about business issues. You know what I mean?
So there'd probably be no point in overturning the designation and starting that over.
No.
Well, I'd say and I had corrected myself and said de facto repeatedly. Default was a word I think we've used before in regards, but yes, so it's a partnership unless otherwise stated. So unless there's evidence specifically to the contrary, and then it goes to the complex business court, and ostensibly they wouldn't overturn that. I don't know why they would, because I would assume just land right back in there again, because there's nothing to change that. It's a business dispute. It's going to end up there under the same circumstances. I would assume
it should end up right there. Let me do the super chat. Has the issue of partnership been established? Nick seems to suggest that maybe so. Also, you're looking good today. Oh, I'm talking about the lamp. Hey, F you, Timmy asks, but thanks for the $5, man. I appreciate it. But thanks, and the lamp says thank you. But the issue of partnership hasn't been resolved yet. It has been resolved based on a default, but if the default is set aside, then all that goes away. So that's what we're looking at. One thing I wanted to point out. Let me go. Well, let's look at this for a second. Now, this is a case in which the summons and complaint went to the guy's parents' house, right? And the guy was saying, "Well, I didn't live there, right?" So he goes and he says, he didn't live there," and the court is like, "Well, so the court kind of goes into detail to say, okay, well, this is what you have to do to prove that you didn't live there." So the defendant, right? So it says, in this case, the defendant left without telling Craig, but I think it was his mom, where he was going, and he had only taken along some clothes, leaving the remaining of his possessions behind. So if that's true here, then you have an issue, right? If you could show that Kyle left all his possessions behind. Defendant obtained a South Carolina driver's license. Defendant used his defendant obtained a South Carolina driver's license on this date, but defendant used his North Carolina driver's license, listed Craig's address, right, as the defendant's address. Defendant did not have his mail forwarded to South Carolina, nor did he have a bank account, no bills, nothing, right? He even bought a truck. Even significantly, the defendant considers Craig's address as his home and admitted that his intention of staying with relatives in South Carolina for any length of time. In addition, Craig testified that even though she did not know where her son was at, that's Craig, because again, it was sent to the mom's house, where his son was at any time, she accepted service of process for him at her residence. Her home was the defendant's primary residence. So in this case, they found that, yes, if you have all that, then guess what? You live there. You know, that's your primary, that is your primary residence. So this, I think Kyle can overcome, because I think Kyle can overcome this because Kyle had mail sent someplace else. Kyle, had, all of his, he had the tax returns, he had the mail, he has the lease agreement, he has the mom's thing. So his whole situation, I think, is in a lot better standing than this guy. You know what I'm saying? Because this guy didn't have anything. He sees, he's still saying mom's home is my home. That's different than what we got here. So again, we'll see what happens. But I think, again, I want to manage expectations, because that's one thing lawyers, whatever. If you ever get a lawyer, the lawyer doesn't manage your expectations. You got a bad lawyer. The expectation here is Steve can win. Steve can definitely win. Steve has the presumption. He's arguing Kyle's mom was an agent, and he's arguing that Kyle did get that Kyle did get the papers from the agent, which is his mom. Great argument, can work. Very, very carefully. I think Kyle has the better argument. I think Kyle's argument is better, and I think the case law is on Kyle's side. But again, it's all up to you to decide. So that's where we're at. Let's see what happens. Let's see when this thing goes on Zoom. I know we're all going to be watching it with clutching pearls, so it's going to be great. Nick, before we get out of here, tell people where they can find you. Somebody put somebody put Nick's link to In Time in the chat, and let us know what's coming up in the future, Nick.
Okay, my name is Nicholas Lamar Suter. I am the host of In Time. We do interviews, we do news, we do politics, science, culture. We have on Christopher Mowdy coming up next week. He is going to be discussing what is music. So what is it? Why? Well, a whole bunch of sounds. It has an impact on you, makes you feel a certain way. Why? What is music? We're going to have some live music played. We're going to have a really good time with that show. That is what? I think that's August 19th. We've got Dr. Carrier, and we've got Ozzy. They're going to be coming on for history of. I keep saying history of philosophy of religion. We've had on both Ozzy and Dr. Carrier a whole bunch of times. I'd like to try to. You know what? And we're constantly. We've had on Cirrus, Ocean, Matt Dillahunt, Yaron Ra. We want to try to get him back on in a little. We got it. So we're doing, and we got a lot of good stuff that we're cooking up. So that's what we do. Please do check us out. I have noticed that there is like 237 watching and only 103 thumbs up. Really? Really? I know some of it's hate views, but really? Okay, fine. But that's it. That's where you can find me. I really thank you so much for having me on. I was delighted. And we've had you on a few times.
Yes.
We're gonna have you back on. We're already talking about having you on. Actually, I think we were thinking either tomorrow or sometime. So Nate will be on again soon too. So we're still trying to get the lamp. That's the big guest. But until then we're okay with Nate. He can slum with us.
Well, listen, thanks again for stopping by. Let me get these last two super chats. Learning with Suge, excellent stream. Nate, enjoyed the breakdown. Take care, Suge. And I see you fighting it out on Twitter. I was looking. I was like, Suge is, he's got some problems on Twitter. So Suge, I'm following your Twitter. And Suge, when do you want to come out with another video? Because Suge has some really great videos. I love Suge's channel. Suge, you got to give me something to watch. Suge, I'm dying here. 2 hours from Matt Powell. Kyle should pay McCreepy a little coke to settle. Ooh. That is not good. Thank you, Nate, Lampy, and Nick. Going to sleep now. Good night, Secrets Girl. We will see you on Saturday. Remember, I do my Saturday live streams, 7 o'clock in the morning. Yes, I'm an insane maniac, 7 o'clock in the morning. That's for the people around the world. My name is Nate Brody. For Nick Suda, I want to thank everybody for coming, and we will see you next time.